On Thursday, the Supreme Court upheld 2 voting restrictions in Arizona. 6 justices found the rules did not violate a key provision of the Voting Rights Act. Natalie Brand explains.
On the last day of its term, the U.S. Supreme Court upheld 2 hotly contested voting laws in Arizona. One throws out ballots cast in the wrong precinct. The other restricts who can deliver absentee ballots.
It's historic, quite frankly.
Arizona's Republican Attorney General Mark Brnovich, who defended the laws in court, claimed victory.
It also affirms that states have the ability to enact common sense election integrity measures, and that's what this is all about.
Democratic Party officials had argued the measures disproportionately impact communities of color, but the court's conservative majority ruled the measures were, quote, modest burdens that did not violate the Federal Voting Rights Act. In her dissent, Justice Elena Kagan wrote the court was once again weakening the landmark voting legislation from 1965, saying, "What is tragic is that the court has damaged a statute designed to bring about the end of discrimination in voting."
We're talking about limiting ballot collection. That has a severe impact on someone that lives, for example, on a reservation in Arizona without access to mail in their home and lives many miles away from their polling place.
The ruling comes as a number of Republican-controlled state legislatures have introduced sweeping changes to voting laws in the wake of the 2020 election.
For people who wanted to challenge restrictive voting laws throughout the country, they cannot be excited about this ruling. It's not a good ruling for them.
And Natalie joins me now from Capitol Hill. Natalie, great to see you. Thank you for being with us. So earlier today, you spoke with someone from the Brennan Center for Justice in your piece. What's his take on the argument that Arizona's restrictions were modest burdens to voting, as some are alleging?
Well, you heard in the piece, he brought up the example of voters, Native American voters on reservations who may not have access to mail and rely on services to perhaps help get those ballots to polling locations. We know the DNC in this case had argued that this impacts Native American voters and communities of color, Hispanic voters, African American voters. We know that voting rights groups say that minority voters are more likely to rely on ballot collection services because of perhaps lack of reliable transportation, or they may be homebound for other reasons. Now, the Arizona law does make exceptions for family members or caregivers, postal workers, certain things. But again, the voting rights advocates say that these ballot collection services are really critical to expanding voting options for those who may not be able to go to their polling locations. And another key takeaway from the Brennan Center, you heard our CBSN legal analysts also mention it. There's a lot of concern that this decision today really will limit the ability of groups to bring forward future challenges at a time when we are seeing a number of state legislatures, especially Republican-controlled state legislatures, passing laws that critics see as restrictive. So here we have not only the decision impacting Arizona's policy, but the Brennan Center believes that this really shows us how this current Supreme Court will read Section 2 of the Voting Rights Act, which was key in this case, has a narrow reading of that and kind of really redefines how they will look at these types of cases moving forward, Caitlin.
Yeah, it's such an interesting point because the argument before the court today was focused on the Voting Rights Act. So I'm curious, you know, as you've been talking to some of these groups and since you're on Capitol Hill, is there any sense of what comes next for some of these parties who are trying to fight a lot of these new voting restrictions that are being implemented in the states?
So as you know, Caitlin, all eyes will turn here to Capitol Hill, where there's been a hotly contested debate over an updated voting rights law. We saw that is a proposal that did not move forward in the current 50-50 Senate, the For the People Act. That was just last month that played out. But now there will be renewed pressure on Congress, particularly the Senate, which that's where this legislation has stalled, to try to pass an updated federal voting rights piece of legislation. We know that Senator Patrick Leahy put out a statement today calling today's Supreme Court decision a, quote, body blow to another critical part of the Voting Rights Act. And he said that he plans to soon reintroduce the John Lewis Voting Rights Advancement Act here in Congress, which is separate than the For the People Act. So there's a couple different pieces of legislation that now there's going to be renewed pressure for Senate Democrats to move on that. And we also heard a statement from the president who said the decision today, he called it harmful as it was, does not limit Congress's ability to repair the damage done today. It puts the burden on Congress to restore the Voting Rights Act as its intended strength. But then the question becomes the math, Caitlin, because again, we have a 50-50 Senate needing 60 votes to move forward. So that, of course, is now going to renew debate here in the Senate and among progressives about the filibuster and potential filibuster reform. So you can imagine there's a lot of questions and debates that will still have to play out.
Right, a lot of pressure building, but still a very narrow pathway for it. Natalie, while we have you, I was wondering about the other ruling that we got from the Supreme Court. Busy day at the Supreme Court today. This is about California's donor disclosure requirement. What came out of that?
Well, so in another 6-3 decision really highlighting this ideological split of the new 6-3 conservative majority court, the justices, the majority of them said that charities, nonprofits should not have to disclose their top donors as mandated by California state law, which said they were trying to do this to prevent fraud. But the justices said that does not match what we're seeing here, because there's just a small number of cases that might result in fraud, whereas if you're compelling all of these charities to disclose that information, that could open them up to potential harassment, could deter them from making donations, and ultimately violates their First Amendment rights. So that was another big decision today. The dissenting justices and also critics of this decision fear that it could open the door to disclosure of other sorts and potentially open the door to big money influencing elections or dark money, and the debate around having to disclose who is donating to political campaigns, for instance. So a lot of open-ended questions here as well, and things to watch moving forward.
Lots of implications for these decisions coming down the pike. Natalie Brand covering the courts and Congress for us today. Thank you so much for being with us.
Thank you.